Good evening. I'd like to focus on two questions in my remarks this evening. Uh, Number one, who should decide whether a public functionary who's been found guilty of malfeasance, misconduct, or corruption as a result of a Lokayukt or Lokpal inquiry should be removed from office? Should it be the Lokayukt? Should it be the political executive? If the official involved or functionary involved is a member of the legislature, MP or MLA, should Parliament or the State Assembly decide, or should it be the judiciary? This is a very complex and a difficult question, but a crucial question in ensuring that there is accountability at the top for corruption and other types of malfeasance and misconduct. The second question is, what kind of safeguards are necessary to ensure that the power is not abused by by any of these institutions that could be or are holding the power to remove? I'll address these two questions in light of the interventions already made by the very distinguished panelists, drawing on their submissions as well as on the background research work we've done for this webinar. And now, when we take the first question, who should decide that a public functionary should be removed? And we look at the existing legislative framework at the state level for Lokayuks and the National Lokpal Bill, it is clear that that the upper hand in taking this decision is with the political executive, and not with the Lokayukt, and certainly not with the judiciary. So then, if that is the case, the question is whether or not the core purpose of having a Lokayukt, Lokpal mechanism is defeated by handing over to the very branch of government or the very segment of the state that is to be held accountable through the Lokpal machinery, namely the political executive. It controls the ultimate decision on whether or not they will be held accountable or removed. This is a very significant question, and clearly the answer is yes. And I would argue that the lack of legislative clarity on these crucial issues in the Lokayukt laws and in the Lokpal law now is one of the important reasons why the anti-corruption legislative framework is not functioning effectively in our country. So then, if the dominance of the political executive is not acceptable, what is the alternative? Shall we go the other extreme and make the Lokayukt, give the Lokayukt the last word? Indeed, that was what was done in the 1999 Kerala Lokayukta Act, where the Lokayukta had the power to remove public functionaries, including the chief minister, ministers, MLAs, and state-level office bearers of political parties, and a whole host of government servants and designated public servants who are not government servants, in the following manner. They could inquire into the complaints against these officials, and if they came to the conclusion that the complaint was quote-unquote substantiated, then they could give a declaration saying that the complaint is substantiated, and also expressing the view that in their opinion the concerned public official should not continue to hold that office. And upon issuing this declaration to the competent authority, who could be either the governor, the chief minister, or the government itself, or other officials specified or designated by the government. Once this declaration was issued to the competent authority, then the concerned official will have to resign or vacate office. Except government servants will still protected by the constitutional provisions that protects the civil servants, and they will be placed under suspension, and appropriate disciplinary action will be taken against them under the laws applicable to them. So this was the mechanism in the 1999 Act, but looking back, one can say that it has not had a significant impact in reducing corruption in Kerala or changing the path and the trajectory of the anti-corruption initiatives and efforts of the government. So one can sort of come to a reasonable conclusion that putting this power into the hands of Lokayukts on a unilateral basis did not have an impact, and we haven't studied this, but very possibly it may have actually led to the political executive becoming more sensitive about who they pick to be the Lokayukts or the Up-Lokayukts, so that their bets can be safe and as safe as possible for themselves. Indeed, the current Lokayukta, whose declaration under this law led to the resignation of a minister in April 2021, almost a year ago, and therefore led to an ordinance that amended the law, was selected by the same government that is now in power, the Left Democratic Front government. So it's not obviously it's not clear that by picking someone you can you can kind of control the results of what that person will do. Not at all, but still that I'm sure would be one of the considerations weighing in the minds of those who are selecting Lokayuk. So I think that's also not a good, in the real world, a good solution, because at best it may actually end up having a negative impact on the independence and strength of people who are selected into those into the Lokayukt positions. So then what is the alternative? So that brings us to the second question, which we need to explore much more. This webinar is only a beginning, namely what kind of safeguards are necessary to ensure that the power to remove is not abused, whether by the Lokayukt or by any other functionaries involved in the process. So the solution is not to either give the power to the Lokayukt as the 1999 Act did, or the ordinance, the February 2022 ordinance, which went the extreme went to an extreme in the opposite direction, namely vested the power, the ultimate power to decide on removal in the hands of the competent authorities, the political executive. Neither of this is acceptable. Neither the ordinance nor the 1999 Act offer us an effective framework to construct the role of the Lokayukt. Therefore, we need to move forward in a new direction. And broadly speaking, that direction is consists of about 10, can be explained or can be described using 10 core principles. The first core principle is that the jurisdiction and the role of the Lokayukt should be crystal clear. Particularly the intersection of the Lokayukts with other statutory frameworks providing for penal offences as well as civil liabilities for various kinds of misconduct. For example, the Prevention of Corruption Act or the Sexual Harassment in the Workplace Act provide very specific frameworks for tackling corruption or sexual harassment. And if there are complaints that come to a Lokayukt involving on the criminal side, the Prevention of Corruption Act, then clearly the Lokayukt's role would be to ensure that necessary sanctions and approvals are provided, and that prompt and effective action is taken to investigate and prosecute the offences, the alleged offences in competent courts, rather than substituting the role of the criminal court and carrying out the trial themselves, which they are not intended to do, and no one has tried to do that either. So similarly on the civil side, if there is a provision, if there's a complaint that is in violation of any provisions under the Sexual Harassment Act, for example, the question will arise whether that matter should be handled by an internal complaints committee or by the Lokayukta. And clearly the internal complaints committee mechanism is far more detailed and far more clear about how these procedures should be looked into, and so therefore there must be deference on the part of the Lokayukta to that specific statutory framework. So the first point is that the role of the Lokayukta should be clear, conduct the inquiry, and come to certain conclusions, and certainly as part of that recommend corrective action, including sanctions or any other corrective action as action that is required, but with deference to criminal statutes and civil statutes which provide for fact-finding, guilt-finding, or remedies which are of a specialized nature. That should be made very clear in the state statute that will emerge out of this ordinance in the form of an amendment. In addition, we also have to remember the Representation of People's Act, which provides for a sanction of disqualification, and for 6 years, depending on the type of offence involved, under section, for example, 8 under the Representation of People Act, for example, convictions under the Prevention of Corruption Act. So if there is an offence contained in a complaint, and that offence is a criminal offence, and that criminal offence is listed under the Representation of People's Act as being a statute with respect to which, if there is a conviction, that will result automatically, virtually automatically, or by operation of the Representation of People Act, disqualification from Parliament or Assembly for a specified period for the concerned public official, there should be, Lokayukta should certainly have deference to that mechanism, and there will be no need to take any other decision for removal from Parliament or Assembly, certainly when it comes to not only the Prevention of Corruption Act, but a whole host of other criminal statutes that are listed in the Representation of People's Act. So the first large point is that we have to be very clear about the intersection of the role, the role of the Lokayukta, and the intersection of that role with other methods of removal of public officials, and ensure that the Lokayukta complements and supplements rather than substitutes or inadvertently undermines those frameworks. The second suggestion is that, subject to this consideration, the primary responsibility for holding a public official responsible for wrongdoing, misconduct, misfeasance, must be with the Lokayukta and cannot be with the political executive, and need not be, can be, but need not be in the first instance with the judiciary in areas that are clearly defined as falling within the jurisdiction of the Lokayukta. And equally, the recommendation on sanction and what should be done against, what action should be taken against a public official, should also be the responsibility of the Lokayukta and not the political executive or the judiciary in the first instance, because the judiciary will have a role of reviewing these decisions, and if it becomes the decision maker, then we will not have the same scope for judicial review. So the second principle is that the Lokayukta should be the primary decision maker on guilt as well as on liability, as well as on sanctions and actions that should be taken, including removal from office, subject to the provisions of other legislation, as we said. The third principle is that this role should be in the form of a recommendation and not in the form of a final decision. That recommendation can be made or should be made, as is now done, to the competent authority, and the competent authority may consider the recommendation and either accept or reject. But the recommendation should normally be accepted. That is one of the recommendations that have come out from other panelists in this webinar. It should normally be accepted. And if it is not accepted, as Justice Sikri said, then it should be rejected on the basis of cogent reasons which are set out in writing by the competent authority. And it should be subject to the constitutional law, natural justice, rule of law standard of cogent reasons of decisions or having to be made on the basis of cogent reasons in such cases. So the first decision should be on the part of the Lokayukta. It should be in the form of a recommendation. That recommendation should be made to the competent authority. It may be accepted or it may be rejected. If it should normally be accepted. If it is rejected, then cogent reasons must be given for their rejection. Fourth, the decisions of the Lokayukta and the competent authority must be subject to judicial review. Statutorily subject to judicial review, not under writ jurisdiction, where the affected party, the public official or the complainant, as well as any member of the public acting in the public interest, will have the right to seek judicial review. And the suggestion that has come from our very distinguished panelists is that it should possibly be a full bench of the High Court that reviews it, given that the Lokayukta is normally a retired Chief Justice of a High Court. It would be appropriate that a full bench reviews the manner in which that recommendation is handled by the political executive. So judicial review must be provided for the decisions of the Lokayukta as well as the competent authority. And number 5, the competent authority's processing of the recommendation of the Lokayukta should be within a framework that is clarified in the statute itself. It should always be acted upon. We have heard of many instances where the Lokayukta's decision is ignored or not acted on, kept in abeyance until it becomes infructuous. These kind of things are not acceptable, and they will destroy the effectiveness of this framework. So the statute must provide that every recommendation of the Lokpal is acted upon, either accepted or rejected within a stipulated time frame, and cogent reasons must be provided for the actions that are taken. Also, the processing of the recommendation of the Lokpal must ensure that the Lokpal's recommendation is not subjected to a further round of investigation or review by the executive, the political executive, through its police or other forces. The Lokayukta has already carried out an investigation and has come to a conclusion, and that recommendation of the Lokayukta and the conclusion must be taken with all the respect it deserves and not be subject to further review by the political executive. The next principle is that there must be a strong framework for Lokpal accountability. For example, there must be a clear code of conduct for the Lokpal institution, and there must be also a monitoring mechanism for ensuring compliance with that code of conduct, and a complaint mechanism where any complaints against the Lokpal, any official of the Lokpal could be lodged and could be independently reviewed, independent of the Lokpal itself. And this will ensure that the kind of really avoidable situation we've had in Kerala, where the minister who was removed by declaration has made serious allegations against the current Lokpal, and that's been ignored by the Lokpal. But it is hanging in the air, whereas in fact these kind of complaints should be reviewed and handled through a mechanism, and if they are made wrongly or maliciously, then there should be accountability for those who make those allegations in a malicious manner and a malafide manner. If not, there should be accountability with respect to, I'm not talking about any particular Lokpal, but there must be accountability for the Lokpal and or its officials if there is some wrongdoing on their part. This level of Lokpal accountability is important because these are human institutions. There is a risk that the Lokpal will make errors. There is a risk that the Lokpal may come to a judgment which other tribunals, larger tribunals like a judicial, a full bench of a high court may not agree with. And so there is room for a reasonable alternate judgment, and that opportunity must be given to those who are affected. And there could also be, given the power of the institution, there is also a very high likelihood that there could be bias, that the Lokpal institutions could be corrupted, and their decisions may lack integrity. So there are a number of risks involved, which I think should be should be addressed through a strong framework of accountability for the Lokpal mechanism. Let not the institution that holds others accountable be any less accountable than they expect the other institutions to be. Similarly, the next principle is that the Lokpal must function in an extremely transparent manner. There may be some need for confidentiality for protection of whistleblowers, and we'll come back to that in a minute. But subject to that, all its proceedings should be transparent and should be available on the website, and should be public. Equally, it's important from experience to ensure that there is no soft or hard retaliation against the Lokayukta institution. Much of what I say when I say Lokayukta applies also, not all of it, to also the Lokpal institution. But there should be a protection for the Lokayukta institution from retaliation by the political executive or the bureaucracy in small ways and big ways, and that must also be written into the statute. Finally, there must be a strong protection in the law against whistleblowers. We do not now as yet have a strong national law on whistleblowers, which is essential if an anti-corruption mechanism is to work effectively, especially because many of these statutes, if not all of them, have strong provisions for prosecuting those who make false complaints. So there are already deterrents in these laws for people coming forward and making complaints, because that involves their taking huge risks. So it is important to have whistleblower provisions written into the Kerala amendment that will emerge from the ordinance, and ensure that the complaints are brought to the attention of the Lokayukta mechanism effectively and promptly. So these are some of the safeguards, some of the key safeguards that have emerged from our discussions that should be written into the amendment bill that will replace the ordinance. And as I said, what we suggest is that the amendment bill should not either follow the 1999 Act or the ordinance for reasons already explained. They're both problematic, and instead what the amendment bill should do is to propose a model where the initial determination comes from the Lokpal, Lokayukta, in the form of a recommendation, and that is submitted to the competent authority, and the competent authority then makes a determination, normally accepts the Lokpal's recommendation. If it does not, then if it rejects it, it provides cogent reasons for the rejection, and all of these decisions are subject to judicial review. And there are also these other protections to ensure the accountability of the Lokayukta mechanism, whistleblower protection, and the standards of proof and decision making being made adequately clear, as well as the jurisdiction of the Lokayukta. So with all these detailed safeguards, perhaps Kerala has an extraordinary and historic opportunity to come to take the development and evolution of the Lokayukta mechanism one step further by coming up with a next generation framework for Lokayukta's role and accountability, which is a strong role for the Lokpal, but with strong accountability and strong safeguards. We hope that these ideas will be considered duly by government authorities in Kerala, and we hope that they will find these ideas useful. I'd like to stop here and thank everyone for listening to this webinar. Thank you.